All rise. Yes, Mr. Setrai.
May it please, my lords and my lady, we are grateful on behalf of the intervener to be permitted to address the court, and may we apologise for the lateness and the somewhat eclectic nature of our written case, that we took the view that having come before your lordships as neutrals,
Yes.
we possibly should be providing thoughts and pursuing lines which might or might not be of interest to my lords, but which might add to or sometimes not coincide with that which had been placed before my lords by other parties. My lords, because my time must be limited, what I'm going to do, subject to your lordships, is to do a little updating and then to follow some themes through without necessarily slavishly following the written case, which my lords, despite its great lateness, may have had the opportunity to read.
Yes, we have.
I'm very grateful. We tried to proceed thematically in the written case, and we started with habitual residence, which your lordships have not pursued, notwithstanding their willingness to participate with the other parties. I'll take my cue from that and won't go into habitual residence, save in this regard. In the bundle of authorities, placed there very recently at tab 76, is a very recent decision of the English Court of Appeal, which we believe to be the latest work on the subject. My learned junior, it's in a separate file. It's a case called Ries, a decision of the 30th of July this year. And it was to be the test case, so far as the Court of Appeal was concerned, on whether the Marinos European jurisdiction was the one to follow on habitual residence, or whether what one might call traditional English still ruled, by which I mean Nessa and the attendant learning. But at the last, the matter rather disappeared, because if I take my lords to paragraph 8 of the judgment of Lord Justice Thorne, it explains that the decision of the ECJ, reference C52307, which my lords have been taken to by various of the parties, led to counsel for the appellant abandoning his submission that Marinos should be applied, but also, importantly, making the concession to be found at the end of paragraph 8, it's common ground that the European Court did not favour a centre of interest test, but a fact-based inquiry, and then the interesting words, broadly akin to the approach of the authorities in this jurisdiction. Thus, the concession made by leading counsel on behalf of the appellant was to that effect. So the matter has never, as it were, been determined in anger. There's never been an adversarial hearing. But that was the resting place. That brings my lords entirely up to date, I think.
In view of what you say, it probably doesn't matter, but I have a feeling that the print we've got is incomplete. It seems to peter out at the end of a large quotation, and we don't have, at least in my copy, I don't have any more than the end of paragraph 13. Am I?
Mine goes up to paragraph 21.
Mine too.
Well, that says just a defect in my copy.
Well, my lord, we will rectify
But,
your lordships.
Well, I was saying it doesn't seem to matter if it peters out after paragraph 8. I don't know that we're going to learn very much from what else is said.
The only matter that may be of interest is that Mr. Turner, Queen's Counsel, sought to submit that there was a real home test that was also rejected.
Yeah.
But because my lords have not pursued habitual residence, probably I don't need to take my lords to it, and my lords don't need to read it.
Well, I thought, looking at your written paper last night, that we really began at page 17, which is where we look at Brussels 2 revised.
Yes, Lord. And
That's where assistance would be very welcome.
gradually that awareness has come over me. So I'm there. So moving relatively swiftly away from habitual residence, the one area in which I might perhaps tentatively demur is that we did pass briefly over parens patria, and it may just be that my lords will have in mind the residual parens patriae jurisdiction that is still very, very occasionally used in English children's cases. And we placed before your lordships at tab 55 the decision of Mrs. Justice Holger, a very, very experienced judge of the family division, in Re B, a Pakistan case in which, as the headnote reveals on the first page, while the court accepted that it should be extremely circumspect in assuming any jurisdiction founded on nationality alone, and pausing there and putting myself in context, my lords will be keenly aware by now of the references to nationality in the revised regulation. Founded on nationality alone in relation to children physically present in some other jurisdiction. In these dire and exceptional circumstances, the tentacles of the court could stretch towards Pakistan to rescue a girl who was and always had been a British child and who was seeking British help. It would not have been right to ignore her pleas. Each case would turn on its own circumstances. Only if the circumstances were sufficiently dire and exceptional would such an unusual order be made. Well, I can tell my lords that it is indeed exceptionally rare for the parens patriae jurisdiction to be used, but there are cases where it is still used. Could it be that the Brussels regulation, with its interest in nationality, is one which is capable of providing a refuge of jurisdiction for its citizens in the way that by different routes the English jurisdiction provided a now almost disused parens patriae jurisdiction. My lords, I will move on from there.
How would it do it?
Perhaps, my lady and my lords, by the route that's being discussed before this court today.
I thought...
But that's only voluntary submission to the jurisdiction, which is not likely to happen in the forced marriage cases that obviously are a considerable concern to reunite.
I indicated by a different route. It wouldn't, in the same way, provide for the protection case, because I think, my lords, that the protection provisions in the Brussels 2 revised regulation, which are careful and considerable, relate to children physically present in the jurisdiction, and one can understand why. The route is different because it's a consensual route that allows citizens, nationals, I'm so sorry, to use the jurisdiction where in other circumstances habitual residence, which is undoubtedly the guiding principle in normal cases, of the revised regulation would say the jurisdiction might be elsewhere.
This was a wardship case.
That was a wardship or inherent jurisdiction case.
But what would be the route under the regulation? Forgive me. In a case such as that.
Ah, no, milady, there isn't a route.
Well, that's what I thought.
Under the regulation for cases without consent, where the child is outside the jurisdiction.
That's right. So,
but there is a route, if my lords accept the submissions of Mr. Baker and Mr. Devereux, where there is a consent.
Well, are you meaning that is this dealing with the best interest point in the last sentence, last phrase in paragraph 12.4? I mean, you've gone a long way through all the hoops by the time you reach that. But is that
just so? And I'm
it only really resonates at that point, does it?
At that end, but there's a certain commonality of principle, arguably, with making a provision which, in very different circumstances, takes cognizance of the child's best interests, perhaps jumping ahead on a very summary basis in terms of the acquisition of a jurisdiction under Article 12, and the approach of the English courts in the parens patriae jurisdiction.
so that's the only point you're making, in effect.
Indeed,
Yeah.
the analogy falls to the ground completely when one looks at the other aspect of the gateway. The revised regulation says there's got to be agreement. So the essentially ex parte application, although at a technically on notice hearing for Mrs. Justice Hogg, doesn't work. Lords, if I can pass on from that to deal with Article 12, and in the order dealt with in our written case, the third state. My lords, overnight, having heard my Lord Collins' perusal of the English and French texts, and these are documents which have been distributed at the bar, we cast the net wider. There is an official European website called Europa. On that, there are the EU's translations of the regulation in all the member state languages. We have provided, my lords, the only changes being a slight removal of gaps so that each fits on one page, respectively with English, French, German, Italian and Spanish. And to save my lords the trouble of identifying the particular parts, as a reminder, in Article 12.4, third state appears twice in the English text and appears once at 61b. Over the page in French, État, capital E, tiers, third state, appears twice in exactly the same context in Article 12.4, but in Article 61, it's different.
Yes.
Sur le territoire d'un État non membre qui est partie contractante, etc.
That's very interesting.
They're looking forward to the German, my lords.
Yes.
But I may do
The
better.
translation of the
And in German, it is straightforward. Article 12.4 in einem Drittstaat, capital D, but then it would be because it's a noun. And the same at the bottom of that paragraph, and equally at 61b, eines Drittstaats hat. Italian is in some ways the most interesting of all. Article 12.4, di uno Stato, singular, which is not a party to the Hague Convention, so not a third state, but a party, which is not a state, which is not a party to the Hague Convention. But then at the bottom, most interestingly, as my lady has spotted, nel paese terzo. And although I am not a translator for this court, that is country, as in the French pays, and not state, and it's a lowercase p. And at 61b, again, no reference to third, di uno stato non membro. And finally, the Spanish, Article 12.4, un tercer estado, twice, but in Article 61b, un estado non membro. I'm tempted to suggest to my lords that one should be cautious in what one makes of all of that, because it is the same regulation. With its first language, we believe, French, but with all those as official translations on the EU website. So to read too much into the Italian use of country with a small letter as opposed to state, and to read anything in particular into the alternations in third state and non-member state, may be unwise. But, my lords, subject of course to any questions that the court may have of me, leave my lords to be the judges of that we thought that the information might be useful to have.
Thank you very much.
So far as the rest of it is concerned, we can't, I think, subject to questions, add very much to what my lords have already been told. For what it is worth, the meaning and the interpretation which the appellants seek to apply seems to be the more straightforward in terms of the drafting and the effect, but it is your lordships and not us who are the judges of that.
What's the status of the cordis definition? It's not a legal source, obviously.
No, I'm leaving it to my learned friend Mr. Gupta, whose researches these were over the weekend, to deal, if I may, with that material, and he's looking forward to it.
Especially now.
So, my lords, if I could pass on, having indicated that we take a tentative position on the interpretation of the third state, if we were to look briefly at a question of effect and a question of what I might term policy, we've been careful about the use of the word policy in our written case, and we've distinguished between this as a regulation, which it is, from conventions where one can look at purpose of intent, and we're mindful of the fact that courts have fallen into error, courts below the level of this court, in seeking to apply policy overmuch in the context of international children's cases. The best known example has been where courts have erred in non-convention child abduction cases by importing what's regarded as the policy of the Hague Child Abduction Convention into non-convention cases where it is domestic law and the interests of the individual child that is concerned. But my lords are entitled, we tentatively suggest, to look at the regulation and to see what it is that it sets out to do. And in our submission, what it sets out to do is, among other things, to regulate jurisdiction, and to regulate it in a way which leads to certainty and an absence of conflict. And so when construing Article 12.3 and Article 12.4 for that matter, one can look to see perhaps with the assistance of the practice guide, what it is that the regulation intends to achieve. And we say, and this comes to the construction of Article 12.3, that it's desirable that within the rules a jurisdiction is discerned with certainty which will stick, I can put it in that way. So the idea of a continuous assessment of jurisdiction, or a jurisdiction without, or a position where there isn't what used to be called a fixed terminus a quo to the determination, would be very difficult to fit in with the intendment of the regulation.
And so you ask us to read the phrase "at the time when the court is seized," with that principle in mind.
If I may, let me, my lords, come to that now. There are a number of possible ways that it could be read, but looking at the sub-article, that the date of seizing is, with respect, clear from the four corners of the regulation by Article 16. Looking at the instant case, one approach that my lords could have is to say, well, what on the basis of all the evidence was the position of the parties at the time of seizing? There we go back, leaving aside for the moment questions of variation and continuation of proceedings, which are interesting, to the undertaking given by the father at the time of the relocation. And his undertaking was to return the child if called upon to do so by the court, not in these proceedings. And it could have said in these proceedings, but it didn't. By the court, that is the English court. The father, therefore, it might be said, was inevitably, and following intensive proceedings in which he had been represented, making a concession for all the world to see, and one which bound him on pain of possible imprisonment, to respond obediently to requests from the English court. Now, my lords, the use of, or the continued use of undertakings in relocation cases has been the subject of much interest to practitioners and of the occasional observation by judges, including in the Court of Appeal. And it's sometimes been said that they're outmoded, particularly in cases where, for example, the Hague Child Abduction Convention applies. This is not one of those cases. And it might be said that in the generality of cases in which the Brussels II revised regulation applies, well, they are outmoded, or they're a clumsy way of achieving an end if what the court really has in mind is a reservation of jurisdiction.
So you're saying that even if the 2007 proceedings were new proceedings, there was still a continuing acceptance of jurisdiction?
There's a continuing acceptance of the jurisdiction of an English court in a case concerning this particular child. And as it happens, both the parties who are the parties to the 2007 proceedings. So if the court wishes to look at it that way,
the moral of the story is not to give the undertaking, but to let the court exact it.
Indeed it is. But perhaps if my lords were minded to consider guidance, one might roll everything together and it would go rather like this. If one is making an order for relocation, there needs to be a positive consideration, one which is overt, as to whether it is intended that a jurisdiction should be retained. If it isn't retained, then if it's a European case, pursuant to Article 9, after 3 months, the jurisdiction will pass, and that will be the end of it, and there won't be a residual interest in this country. Alternatively, looking at what is said to be the approach in cases to which the regulation doesn't apply, with the shift of habitual residence, the jurisdiction of the English court will disappear. On the other hand, if it is sought to retain a jurisdiction, Article 12 provides the route, and arguably that is the time to say to the parties, do you want to retain an English jurisdiction? If you do you go through the hoops, if this is a children's case only, of Article 12.3? That could be recorded on the face of the order, and then there would be no room for doubt, including in the foreign court. Now, that wasn't done in this case, and I have to say, from experience, it tends not to be done, save by rare first instance judges, in any case. Taking it forward, if one considers the effect of Article 17 of the revised regulation, Article 17, coupled together with Article 18, provides a positive onus on judges to consider jurisdiction at the earliest possible stage. And realistically, there's a limit to the scope for that to be done when proceedings are launched. And that comes to the analysis of the interplay between the different aspects of Article 12.3b. That is to say, accepted expressly or otherwise in an unequivocal manner by all the parties to the proceedings at the time the court is seized. Well, at the time the court is seized, it may well be that there is only one active party. The other party won't necessarily have had the chance to say anything at all. And there is a difficulty at the moment with that. It's a difficulty which some practitioners address by writing on a document acknowledging service that the acknowledgement is made subject to a challenge to jurisdiction. And then matters are absolutely apparent from that moment on. But when a case first comes before a judge with both parties represented, or if it starts with a without notice hearing, a direction can be given that the question be asked of the other party. It may be that a positive question can be asked by the judge, even perhaps in cases where it isn't obvious that there may be a problem. As to
But that would be too late, though, wouldn't it? Because all that would be post-season under Article 16.
My Lord, I'll come to an interpretation, albeit an interpretation which may cause a slight variation of the approach of my Lord Collins in Bush, which gets round that. But
I was just reading the language.
So am I, my Lord, but perhaps in a different way. I'll come to it in a moment.
Because we have to fit in this whole notion of season with all the other jurisprudence on season, of which there's been a very great deal.
There is, with great respect to my Lords, no doubt that the date of season is that described in Article 16. It's a fixed point, and it's a very early point.
And it's a point at which the court may have only one party before it.
Precisely so.
And it's a point at which, if little b is to be satisfied, there must be an unequivocal acceptance of the jurisdiction.
Not necessarily so, my Lord. I'll come to that, if I may.
But can I just try to get to firm ground, at least for point one, and that is that you accept, for the purposes of this argument, that seized is the moment when the court is first approached, and the document is as it were, presented to the court.
It can be no other,
so it can
as interpreted by Article 16.
So you're not suggesting that one waits until the court has both parties before it?
Not for seizing, but seizing and jurisdiction, as my lady observed, or perhaps it was my Lord Carr, are not necessarily the same thing.
Right.
But can I come to that?
Yes, all right.
Actually, probably I should come to it right now, and then it relieves the tension in me. If
We're all
one
waiting
looks-
for your magic rabbit to come out of the hat, Mr. Sedgwick.
That's all right. I hope it doesn't fall flat. If one looks carefully at Article 12.3b, and one reads it in this way, the jurisdiction of the court has been past tense, accepted expressly or otherwise in an unequivocal manner, and I'm now going to read it with an emphasis. By all the parties to the proceedings at the time the court is seized. So in other words, that's a description, not at the time at which there must be the express acceptance, but the time at which the constituent parties who have to give their consent are counted. Thus,
So at the time the court is seized is descriptive of parties,
Yes.
not acceptance.
yes, that works.
Wow.
Yes.
That's something.
How does it fit in with Article 90?
Ah, yes. My lords, it does, and if I refer also to Article 17, I think my starting point probably is Article 17.
Well, Article 17 is only about a case where there are two competing jurisdictions, both of which are in member states.
But it's a different principle, my lord. Where a court of a member state is seized of a case over which it has no jurisdiction. So there the regulation...
And over which a court of another member state has jurisdiction. That's what Article 17 is about.
With great respect, my lord, may be so, but it still concedes, within the four corners of the regulation, that it is possible for a court to be seized. So seizing is a technical consideration related to that early point. It may be seized, but nonetheless not have a jurisdiction. And so the question of jurisdiction can legitimately be considered at a time following seizing.
And practically it must be in the vast
Precisely.
majority of cases.
Precisely, because the practicality of...
Well, it has to be considered subsequently, obviously, but the jurisdiction, surely, is, if there is jurisdiction, is as at the moment of seizing.
Save, my
And that's
lord,
the whole way in which these conventions have been construed, surely, for years.
save, my lord, that Article 17 appears to countenance something else.
Well, the court has to make a number of assessments. There's first of all the question of the acceptance, but presumably the court also has to consider the best interests of the child, and it can't do that at the date when it's seized, because it has to have some material put before it. So, I suppose to that extent, there's force in the point that the assessment of whether jurisdiction exists has to be postponed until the court can apply its mind to the point.
Many years ago, this House, and I'm afraid I've not put the authority before the House, considered the concept of retention in child abduction cases. It was H&S. And the parties argued on the one hand, I say this House, the House as was, on the one hand, the contention that retention was a continuing state under the Hague Convention, and one could pick the date that was most convenient for the parties to illustrate a point, or in this case, a date following a contracting state entering the relevant convention. The House said no, fixed terminus a quo, and one has to look at the earliest date of retention, despite the word retention, which carries with it a certain continuum. In this case, we suggest seizing is clear, it's got to be that early moment, that the regulation doesn't give scope for any other interpretation. But an evaluation of jurisdiction will be based on material which, of course, will gradually grow with the progression of the proceedings. And this will be the case in every set of proceedings. It will grow first when a second party is joined in practical terms. Thus, the document starting the proceedings is issued and served, and then in some proceedings, most proceedings, the party served will have the opportunity to respond. Then there will be a court appearance, and then there may be submissions, and there may be evidence. We suggest that there are a number of ways of looking at Article 12.3. One is to say, yes, it's got to be determined at the moment of seizin, with such material as may be available at the moment of seizin. So perhaps a judge, who may be a judge at a very low level in a registry, who receives a paper application, will have to look at it and say, well, does Article 12.3 apply because there is a consent? In that case, there'd have to be a fairly radical overhaul of the way proceedings are started, if people are to have the chance of accepting or not accepting. Second, I'm sorry, yes,
please continue.
A second possibility is that which I've postulated as the rabbit pulled out of the hat. A third is to say the date is the date of seizin. One can look at material which comes to light subsequent to that, but rather as one would in public law care proceedings, one has to look back to that particular date to see what the position was then. There's an argument that in this case such a test would be satisfied because of the undertakings given in the relocation proceedings.
And everything the father did.
And everything the father did.
Subsequently. This is my point about the difference between evidence of what the state of affairs was at the date of seizin.
Precisely.
And acts at the date of seizin.
And particularly the statement of position that says he's accepted the jurisdiction.
Yes. But
only if it did in truth evidence the position as at the date of seizin.
But that's easy in the light of the undertaking.
that would be
the key thing
in the individual case.
Just going back to the question, to your interpretation point, do you have German?
Yes.
Because German order is different. Can you help us on whether the German has at the time the court is seized in the same place, arguably in applying to the parties?
Yes.
Which paragraph?
3B, 12.3b.
I'm going to cheat and compare it with English also. Yeah.
Alle parties die Verfahrenszeitpunkt der Anrufung des Gerichts.
Yes.
Perhaps somebody for the slower members of the class could translate that.
Yes, I don't have German.
All parties to the proceedings at the point,
point
of time of the beginning, the initiation of the...
Yes, my lady. Yes, zum Zeitpunkt, at the moment.
That supports your rabbit.
Yes, I'm not
it
sure.
It may be a German rabbit.
Can I, before we get completely sold on the rabbit, could you look back at 12.1b?
Yes.
Because the same phrase appears at the time the court is seized, surrounded by commas. But does your interpretation work there? I mean, you're looking to see who the spouses are. Are you looking to see who the spouses are at the time the court is seized?
But by the holders of parental responsibility.
Yeah.
So there could be different spouses at different times.
The holders of parental responsibility. Now, it could be that a grandparent, an uncle, or indeed a complete stranger has parental responsibility.
At the time the court is seized.
Precisely. Exactly the same. It works because what plainly it is seeking to do is to define who the parties are at that particular date.
So the concentration is not so much on spouses, which is, but it's on the holders of parental responsibility, you say, and you need to know at what point of time they hold it, or who they are.
If it just said spouses,
yes,
then I might be a bit worried.
Yeah.
But the addition of holders of parental responsibility, they may be different. There may be, and one doesn't want to run too much down interesting roads of speculation, but for example, it could be the case that there was an unenfranchised father at the time that the proceedings were started, who later became enfranchised and a party. Now, if I take that analogy with my lords to the analogy of the child as a party in the present case, and this is where we lead on to, if one takes the view that what Article 12 is designed to do is to look at what the Germans call the Zeitpunkt, the moment in time, and to evaluate the parties at that moment in time. That's for the purpose of deciding on jurisdiction. It relates to season. It means you can join or indeed subtract parties thereafter, as often happens. But it would be intolerable if every time that happened, you might lose, or for that matter gain, a jurisdiction. It would avoid the aim of certainty and definition, which is at the core of this regulation. So, my lords, that's a possible route that we place before our Lord's Court for that interpretation, which rather leaves, if I'm not rushing along too fast, the best interests of the child. When should that be looked at, and to what extent should it be looked at? My lords, one of the things that the revised regulation does is to put a premium on the voice of the child. And indeed, in other decisions of this House in the child abduction field, it's been emphasised that the requirement that a child be heard in child abduction proceedings has caused a change in English practice in those proceedings, and in the speech of my lady, it was made clear that this extended to all such proceedings, not just those under the regulation. And it has. And so what follows is that if a regulation jurisdiction, a regulation primary jurisdiction, is accepted by an EU member state under Article 12.3, it goes without saying that a high premium will be placed on establishing what the best interests of the child are in the subsequent domestic proceedings held under that jurisdiction. And so, of course, it will always be in this country. So, after the jurisdiction has been accepted, there will be ample opportunity in the proceedings for, dare I say it, absolutely anything to be done which the child's best interest required. The principal English statute on children's matters, the Children Act 1989, is an exceedingly flexible statute. And apart from the dividing line between the public law and private law fields, it is hard to think of an order which cannot be made under the Children Act 1989, under the guise of, under the umbrella of Section 8 or otherwise, which would be required to meet a child's best interests. Is there a power to review jurisdiction? Because it's my learned friend's submission that in order properly to give weight to the views of the child and the interests of the child, it's not acceptable that there should be a snapshot taken at a time when the child is not represented, and then the child comes along and the child has nothing that he or she can say about jurisdiction. one looks, my lords, at Article 15.
Yes, I was just going to raise Article 15 because there is the flexibility between member states.
Just so.
But what does one do, assuming you're right about third state, and
Yes.
one's got a child
Yes.
from outside? What flexibility is there once jurisdiction has been accepted?
Well, perhaps, my lords, I'm going to add 2 and 2 and make 5. But if the regulation says that there should be that ability, if there's an agreement and in the child's best interests to transfer a jurisdiction in whole or in part to another member state, what is there to prevent an English court, as an EU court seized, doing the same to a non-member state as a best interests decision? Now, it's hard to find examples where that has been done, but the first analogy I'd take, and we put it belatedly into the bundle of authorities as item 77, it's a decision of the House of Lords in 2005. It's Lee J, the non-convention abductions case, in which my lords reviewed the existence and the exercise of the jurisdiction in non-Hague abduction cases. And my lords came to the conclusion that it was a welfare-based jurisdiction, and one that had to be exercised with safeguards and without regard to the policy of a convention which didn't apply. But nevertheless, the court had this distinctive power to say, following a summary hearing and on the basis of best interests, that the court would direct that a child be returned to a non-convention state on the basis that the welfare investigations, if there were welfare investigations, would not be undertaken in detail in this jurisdiction. Now, the basis of every Hague Convention child abduction return is a return for litigation. I'm sure that I will be corrected if I'm wrong, but the basis of every non-convention return is that it is either a return for litigation or it's a return on the basis that litigation, if required, can safely take place in the other jurisdiction. Rejection comes, as in part it did, if my memory serves me right, in Re J, in cases where it is demonstrated that there may be a real difficulty. And so, my lords, there is an exercise of a children's jurisdiction where the English court says, no, not here, you don't litigate welfare here, in terms of best interests, although in the context of an abduction, you litigate it in another non-convention state. The provisions of Brussels II under Articles 10 and 11, which my lords have mercifully not had to consider, relate to the operation of the Hague Convention. With Pakistan, one is not talking about a Hague Convention state any more than one was with Saudi Arabia in Re J. But if there is a capacity in the English court on a best interests basis to transfer a child and a jurisdiction to another country, why shouldn't it, in the discretion of the judge, be exercised in a way, I must be careful, that might by coincidence be analogous to that provided in Article 15? There's nothing in the English jurisdiction to prevent it. That is a refinement of my learned friend Mr. Baker's no order approach, but only a refinement in a small way, because arguably when an English court returns a child in a non-convention abduction case, it is saying, we are not making orders in this jurisdiction, save orders which facilitate a return for litigation to the other jurisdiction.
In other
and we
words,
are
it's a
not-
decision not to continue to
It
exercise
is.
jurisdiction.
It is. There is a jurisdiction, potentially, in every single non-convention abduction case, because there is a presence of the child, a physical presence, which passes a gateway in the Family Law Act, and there's almost certainly a need for protection also, if there's an abduction, which passes one of the gateways in the revised regulation.
But the court recognises that it has a jurisdiction, but it consciously decides not to exercise.
Precisely so, my Lord. On a welfare basis.
It consciously decides to do something which means it no longer retains control over the child's future.
Yeah.
It's not so much that it's not exercising it, but it's exercising it in a particular way.
It's a deliberate giving up of jurisdiction, and indeed of the physical presence of the child. And it may be that that is the right way, rather than the more approximate and policy-based way that it's been treated in some observations in the Court of Appeal. That's the right way to look at a relocation application and its sequelae, and to take decisions about whether a jurisdiction is to be retained and used thereafter.
But it's not revisiting the question, do I have jurisdiction? You do have jurisdiction throughout, but you decide that you're not going to make orders.
Yes. So
That decision, as my lady points out, is within jurisdiction.
yeah. So if one transports that to my Lord Hope's question, well, what can be done? And looking at Article 15. Article 15, I have to concede, I think, as it's framed, applies to transfers to EU states. But there is nothing to stop judges exercising the power that I've indicated. And that, again, I respectfully suggest would work.
Yeah.
In
It's
those
interesting.
rare...
There is a fallback position in Article 15, isn't there? I mean, if the other member state is not seized,
Yes.
then the court, which has been wanting to transfer, retains jurisdiction.
Yes.
And one would take the same view, I suppose, in the case you're envisaging, that if the third state court, using the third state in the broader sense, would, for some reason or another, was a breakdown in communication, or party just didn't take up the offer, then the court in this country would remain seized and with jurisdiction.
You'd have to be very careful there, wouldn't you? I mean, because if you said you were declining jurisdiction or anything that sounded like it, that would be directly contrary to the principles in EWCA. So you'd have to say, well, we're exercising the jurisdiction by... but whether you could give up all future jurisdiction, I
We
don't know.
recognise that it's not a declining of jurisdiction. It needs to be made absolutely clear. You're taking a decision within jurisdiction not to continue to deal with the case.
I suppose that's what they should have done in EWCA. I don't know whether the European would have warned that. That's really the question, whether in an EWCA type case you could have got the desired results by saying, oh, well, no, we're not declining the jurisdiction. That's a complete fallacy. What we're doing, we're exercising the jurisdiction, but staying.
Well,
The line is very, very narrow, and I respectfully doubt whether the European Court would work.
No, I'm in respectful agreement with that, because EWCA was a stay case, and yet the court treated it as if it were a declining jurisdiction.
Whereas we would have said, traditionally, it was a stay case.
Yes.
And the whole point about a stay case is it assumes the jurisdiction, and then what you're doing is staying the exercise of it. That's precisely what the English court would have said was being done in EWCA if it was awake at least. And but yet the European court said, no. That's declining jurisdiction. And if the substance of the thing is to decline jurisdiction, then the worry is that the European court will say, that's not permitted. And I'm not saying there aren't some mechanisms, and by some clever sleight of hand and the like, it might not be possible. But it's not easy.
If I might suggest, my Lord, the way that it could be done, which would be within the grammar and syntax of the regulation, if there was a rejection, in real terms, a rejection of the extant jurisdiction on new information being received, particularly about best interests, then the decision might well be this, that in the circumstances, some particular factual arrangement needs to be made for this child. it might be, for example, that it
I
is
quite
not...
follow that. If there was some change of circumstances, it would be easier to establish. If there were,
Yes.
the problem would arise if there were really no change of circumstances, and it was really the same old points all over again, but decided at a later date.
It is very hard to think, my lord, although no doubt it's not beyond those who are in this court, of a children's case in which, following a taking up of jurisdiction on this application of Article 12.3, if that view prevails, someone comes along on behalf of the child and makes a submission that the jurisdiction is not in the child's best interest, on other than a factual basis which needs to be translated into some practical arrangement, even if it is only that, for example, the child could not be transported, should not be transported to this country, it's not in the child's best interests, or that there is some particular reason why it is not in the child's best interests to engage in an English process, or some particular work needs to be done in the other jurisdiction. The English court could then say so, and say, in that event, we're not going to make orders, and in accordance with the principle of Article 12, subsequent litigation should take place in the country of habitual residence. The exception no longer applies. That's one way of doing it, which might very well be ECJ compliant, because it would follow so closely on the reasoning of the regulation itself.
Article 15.
And Article 12, yes. Arguably, because if our interpretation of Article 12 is right, it provides a gateway to jurisdiction, but there are other doorways out, which Article 15 is one.
Yes. There's a great deal of learning in relation to Brussels Convention and Brussels I, yes. On whether you can apply to non-member states, by analogy, the provisions of the regulation. I mean, it's a difficult one.
Well, I said that I cautioned myself when I said using Article 15 as an analogy. It might be no more than a coincidence in consideration of welfare, which is exactly the approach in a non-convention case where one doesn't follow by analogy. Indeed, one is strongly cautioned against doing so. The concurrent international convention. But in many cases, welfare drives the court down the same route. Well, my lords, I'm conscious of the fact that I've taken up my hour. And may I just see if there's anything else that I can very quickly take your lordships to. I think, yes, I should say this, that if my lords accept the approach that we've just outlined, the investigation into welfare need only be very summary and related to jurisdiction at the outset. And my lords will appreciate that consideration of welfare runs through as a paramount principle virtually every aspect of every children's case in this country as a matter of domestic statute law, and before that as a matter of in the inherent jurisdiction. But, exactly as my lady said, whilst the judges who deal with family cases at first instance are utterly familiar with that concept and will judge almost every aspect of everything they do on the basis of best interests as well as human rights, the weight that is given and the coloration that's given to that aspect will vary. And so if one is looking at a decision on jurisdiction, it will be a very different approach to, for example, whether there should be a relocation, whether there should be a switch of primary carer, whether a child should have medical treatment, because one looks at the potential effect on the child. I don't want to go too far down that road, but it is consistent, we say, with a relatively broad brush approach.
Are you saying the presumption in 12.4 won't have very much weight.
In this sense, that it is not of great significance in the context of what the decision is.
But it is of significance if what one's dealing with is a situation where you haven't got reciprocal obligations. That's the point, isn't it?
Well, that if
among member states there
Yes.
are reciprocal obligations,
Yes.
and the 1996 Hague Convention introduces reciprocal obligations. Some of them member states and some of them are non-member states.
Yes.
But if you haven't got reciprocal obligations and you have a submission to jurisdiction here,
Yes.
well, then you do start from the point of view it's not a bad idea to go on and accept that submission, don't you?
I believe, my lady, one does. It's a rebuttable position, and one may look at it country by country, perhaps, and
Yes.
case by case.
Yeah.
And there, that's a parting word, unless my lords want more. The Pakistan Protocol, the approach that we've placed before the court, is actually complementary to the Pakistan Protocol. The Pakistan Protocol is a beneficial, informal arrangement. We don't subscribe to the criticisms that are made of it. It's only an informal judicial arrangement for so-called normal cases. It's not a binding convention at all.
Was it designed very largely to deal with child abduction?
Yes, it was. And it was designed, and I should confess that I was part of the panel present almost at its birth, as indeed I think was my lady.
I was certainly physically present.
Yes. My lady
I have vivid recollections.
physically present at the birth, as was I.
Was this a visit to Pakistan?
No.
No,
because
this
there
took
was
place
one.
in the Royal Courts of Justice, and in the end, the then President of the Division and the then Chief Justice reached an agreement.
Yes. Well, I'm interested, and no doubt
But
Lord
there
Kerr
was a
is.
visit to Pakistan.
That was following.
Yes.
Oh, I see. That was
The-
to celebrate the protocol.
I wouldn't put it that way. The protocol was born in the Royal Courts of Justice.
But it had to become a UK protocol, and as I understand it, Lady Smith and somebody from
Yes.
Northern Ireland too.
Justice Gillen.
They were present.
So there was actually a three jurisdiction.
Absolutely so.
approach to
They
it.
were present. But it's an informal judicial protocol. The way this arrangement would be complementary would be this, that if it were to be the case that an English court decided by a coincidental analogy to Article 15 to transfer part of a jurisdiction, the Pakistan Protocol, with its judicial links, would provide an ideal way for this to be considered. And so far from driving what in convention terms is to be called a coach and four through the Pakistan Protocol, this interpretation would be consistent with the spirit of cooperation, which is at that protocol's heart. But to talk about the policy of the Pakistan Protocol and to suggest that that should impede a particular result in the case of a particular individual child, at the risk of criticising an eminent judge in the Court of Appeal, may be going too far. It may not be an appropriate consideration. But as it happens, we say that the objectives of the Pakistan Protocol are probably assisted and certainly can be exploited in this interpretation. In other words, I've taken up a great deal of the
Well,
court's
we're
time.
extremely grateful.
Is there anything else?
I don't think so. But Mr. Gupta, I think you had one or two points to add,
Yes.
but I don't think you've got very long, if you
Not
will.
very long at all, no. Can I just endorse everything my
Yes.
Lena has said? If I invite the Court of Lordships to have a look at tab 71 in the files, someone will get to hand up these papers in a ring binder yesterday. You'll hopefully come across a Staples document. And about 3 pages from the end of that Staples document, tab 71, Your Lordships and My Lady will see there, at page 12 of 13, a definition of third state. It's a glossary of terms.
Yes.
As part of the Cordis Community Research and Developmental Information Service of the European Commission, a glossary of their terms, and of course it states then, I'll read it out for those that don't have it in front of them, third state means a state that is neither a member state nor an associated state. Examples of third states are European newly independent states, NIS, Mediterranean partnerships, countries with cooperation agreements, international organisations, and other non-EU countries on a self-financing basis if their participation is of substantial added value to the objectives of the programme. The programme is dealing with, unsurprisingly, international development. And in answer to, well, if one turns one page on, you'll see there what Cordis does. The reason why I and my land leader thought that it was a worthwhile document to include in the bundle was the provenance of it.
Yeah.
Really the provenance.
Yeah.
And the fact that it gives a little handy definition of third state, of course. Over the page, the next tab, at tab 72, second page, and this I hope answers my lady's question, what relevance does it have? Well, some is really the answer. Because we have there a disclaimer at the top of the second page. However, the Commission accepts no responsibility for any liability whatsoever with regard to the material on this website. This material is information of general nature only, which is not intended to address the specific circumstances of any particular individual entity. So I had to put that in as well, just to show the court that really how far does it take one. But again, it's the provenance. It's coming from the European Commission. And I hope to assist in Lord Carr's question yesterday about other disciplines, other areas of work. Has the phrase third state been used? Well, moving on to tab 72, there are a couple of cases which are referred to in summary in tab 73. There's one page in tab 73 that summarises everything that's in tab 72. And those are two ECJ cases dealing with member states' obligations toward third states. If one looks at the bottom of page 73, sorry, tab 73,
Yeah.
it's got the phrase third states there. And if one goes back to tab 72, you have there the two judgments that are referred to, as well as the opinion, I think, of the Advocate General. The third states referred to, if one looks at the front of tab 72, are countries that are outside the EU. Republic of Korea, Republic of Cape Verde, People's Republic of China. And if, for example, one looks at paragraph 23 of that first case in tab 72.
They're described as third countries.
Yes. Now, that's not third states, of course. And it's countries with a small c.
Yeah.
And again, further to the judgment of the court, it's about 3 pages on. This is the other case, the Swedish case. Again, the third countries were the Argentine Republic, Bolivia, Ivory Coast, Egypt, Hong Kong, etc. And at paragraph 42 of that judgment.
Yes, and 28 as well.
Yes, 28 as well.
It looks as though the language of the court favours third countries.
Yes.
And one doesn't get much help. But we're looking at a regulation, of course, and it's the way the Commission and the party, the Council, indeed, expresses itself that we're looking at.
Yes. Is it a term of art, as my old
Yes.
friend
Yeah.
Mr. Begg, Queen's Counsel, said earlier on yesterday? Over to tab 74.
They'd have to use that in a case involving Korea because it's not recognised as a state.
Yes, I do. Yes, indeed. Yes. But as I said, at 73, there's the explanatory. It's an article that first alerted one to the existence of these cases.
I'm wrong, actually. It is recognised. Yeah.
73, did you say there was something?
73 was the explanatory article. 74 is just an excerpt from a protocol to 1997 treaty, where Article 1 speaks, United Kingdom shall be entitled, notwithstanding Article 14 of the treaty, establishing European Community or any other provision of that treaty or the Treaty of European Union, on European Union, any measure adopted under those treaties or any international agreements concluded by the community or by the community and its members with one or more third states. Now, it may be that one's dwelling too much on it, but of course it says its member states, plural.
Well, the context provides the answer there very clearly, doesn't it?
Indeed, yes. So that was the sum total of a certain amount of hours of research over the weekend to try and distill and provide your lordships and my lady with some extra information on the phrase third states.
Thank you very much.
Just briefly.
Mr. Setright wants me to mention a last authority, which I don't know if it's been handed up. I gather there are copies of it. It's Re-SR. Perhaps that can be handed up by Mr. Baker. And I was given a copy of this earlier on. And this is an Article 15 request to the Spanish court from a learned judge, as he was on that day, Mr. Jonathan Baker, Queen's Counsel.
Yes.
In front of him was learned counsel, James Turner, Queen's Counsel, Ian Cook, and Henry Setright, Queen's Counsel, and Mr. Hassan Khan. And that involved divorce proceedings that were going on for some time in Spain, a contact order that was made within the Spanish proceedings as part of those divorce proceedings, an attempt by the father who was in Spain to enforce his contact in this jurisdiction, and paragraphs 72, I gather, and 76 deal with the request to the Spanish court for the English court to take over jurisdiction of the matter. That's the correct reading of that. Yeah. So rather than transferring abroad, it's the opposite. It's inviting under Article 15 a transferal of jurisdiction. But that's a relatively recent example of Article 15 in operation.
Thank you.
Can I assist the court any further? I'm most grateful.
Thank you very much indeed, Mr. Baker.
I'm sure the court would have cited me, so I thought it.
What happened later? Was it successful?
It's interesting in a number of respects. What happened was that the child, they're living in England. The Spanish court agreed to transfer the jurisdiction of this country.
I see.
And the case is, I believe, either ongoing or it was transferred down to a county court.
Yes. Oh, that's very satisfactory.
A county court judge in the north of England where the mother and the child are living.
Yes.
Liverpool, that's right.
Right.
And it's an interesting example of how the process works. Whether the authority considers representations made by Mr. Setright on Article 12, which don't relate to this case. I think it goes to address the court on this stage. Dealing with the specific clauses in the case, I don't know if there's anything more about third state.
Don't think we need any more help on that, but we obviously need some help on the the more important issue that's emerged about unequivocal acceptance and timing.
Well, Mr. Setright was kind enough to demonstrate the round and half a hat to me over a short journey. And I asked him to demonstrate in Spanish, German, Italian, and French. And we adopt the interpretations of the phrase at the time the court is used simply defines the parties and not the unequivocal acceptance. And that has the advantage, huge advantage, of getting around the conundrum. How do you prove unequivocal acceptance or express agreement at a very specific moment before the parties may know, all the parties may know the existence of the proceeding?
And are we on our own on this? There's no jurisprudence from other places to help us on that.
None of us have ever found any other cases other than one we put before the court on buses, on Article 12.
And you would read Article 12.1, that passage in 12.1b, I think it is, in the same way, would you?
Yes, interestingly, of course, yes, one notes the commas in Article 12.1 and 12.1b. So there are commas after the word parental responsibility, which might be thought to indicate the phrase does, and by the holders of parental responsibility, comma, at the time the court is seized the comma, and in the superior interest.
And is it focusing then, it's not on spouses, but on the holders of responsibility?
Yes.
It's intended to qualify that latter noun.
Yes, it would. And interestingly, of course, in this jurisdiction, applications for orders under Section 8 of the Children Act, the parties, the applicant and the respondents, are the parties in parental responsibility, or rather, all parties who have parental responsibility are automatically joined as respondents to the proceeding. So, in other words, they would be the parties under to be considered under Article 12.3. Unequivocal acceptance, I reiterate, if I may, just the broad submission you make, which is that you look at, in the absence of express agreement, you look at conduct. I remind the court, I don't think in fact I mentioned yesterday, but in the practice guide, there's a specific reference to that at page 16 of tab 2. Of the authorities. Situation 1. And of course, that is in relation to Article 12.1. Second bullet point in Situation 1. The divorce court has jurisdiction provided the following conditions are met. Second point. The judge should determine whether, at the time the court is seized, all holders of parental responsibility accept the jurisdiction of the divorce court, whether by formal acceptance or unequivocal conduct.
Because that's a different construction than the one being advanced. So, but this is the construction we're advancing before.
Yes. This puts the phrase in commas before rather than after the holders of parental responsibility.
And so does it on page 17.
Indeed.
On the question of unequivocal conduct, the same point would apply to Article 12.3, Situation 2. So my submission on unequivocal acceptance is it can be demonstrated, the paradigm example is manifestly express agreement, but in the absence of express agreement, the court is entitled to look at the whole circumstance.
Can you make this agreement any time?
You would have to make the agreement before the question of jurisdiction was considered.
It doesn't have to be an agreement, it has to be acceptance.
Yes.
So the undertaking could form that acceptance.
The Lord Clark asked me about the agreement, but I answered that.
Well, or undertaking, I mean, whichever it was.
Well, at the point the court considers jurisdiction, it has to consider, is there unequivocal acceptance? In the absence of an express agreement, which clears the matter up, it looks at all the circumstances of the case, and in particular looks for conduct indicating an acceptance.
And you could have cross undertakings. Otherwise, you don't have an agreement as such, but both parties, in their separate ways, for their separate interests, have given undertakings to the same court. And,
you could
draw conclusions.
You could. Of course, we're dealing with an imperfect situation where the court has to. We are now looking at this court is now looking at the situation several years on from the moment when the matter of jurisdiction could.
I still don't understand why you talk about the undertaking, for example, being conduct. The undertaking itself is acceptance.
Well, I won't seek to quarrel with my lord on that point. It is acceptance at that point. One could interpret it, maybe this is the interpretation your lordship favours. That is indicating acceptance, and unless and until it is withdrawn, that acceptance continues.
Well, it can't be withdrawn except by order of the court.
Well, my lord, maybe I'm not putting the point with sufficient forcefulness, but if that's your lordship's view, then I won't, of course, seek to dissuade you. But in fact, what's happened since then is everything that's happened since then has underlined that the father continues to accept the jurisdiction. Yes. He turns up at the first hearing before the deputy district judge and accedes to an order, all the way through to the position statements in which it's expressed.
And the mother accepts the jurisdiction by making the application.
A consequence of the interpretation Mr. Setright puts forward is that the voice of the child would not be heard on jurisdictional issues, save in circumstances where the child was already a party. In my submission, that is an inevitable consequence of the interpretation which he puts forward, and indeed the earlier interpretation that we put forward. But it's our submission that assessing best interest is a matter which the court has to conduct, as my lady points out, whether or not the child is a party. The court might conceivably decide to join the child as a party to the proceedings and ask for a guardian to prepare a report on the question of best interest before determining jurisdiction. That's unlikely. The court might, more probably, in certain circumstances, would ask CAFCAS to carry out a short investigation just to advise it as to what the best interests were on this point. But ultimately, it's a matter for the court to determine whether or not the child is a party, as the court is frequently having to do in family cases generally. I was going to make one or two comments on other points which have arisen, Lord. Are there any issues on the key issues in the case, that's to say, third state, best interest, unequivocal acceptance, at the time the court is seized, which your lordships and lady would be assisted?
I'd just like to ask the question I just asked a moment ago. That is to say, is there any... the notion that it's got to be this acceptance or agreement, let's call it an agreement for the moment, it could be an acceptance, I recognise. Is there any limit in the article as to when you could make that agreement? I mean, can you make it after there's been, I suppose it's held that there's no sufficient agreement for the purposes of Article 15, or sufficient, and then can one say, well, okay, well, make one?
My suggested interpretation would be it is possible to do it at any point up to the moment that the jurisdiction falls to be considered by the court.
Well, why then, even then, why not afterwards? If you didn't make a good enough agreement the first time, why not say, well, if there was a very good one, we'll make another one?
Well, the court
make insufficient acceptance.
The court has
the jurisdiction.
The court is considering jurisdiction at that point. It has to ask itself, do the parties agree?
They can say, well, I suppose the court says, I, the judge, I'm simply not satisfied that there was any sufficiently clear and unequivocal acceptance. Could the parties then, as long as it were the parties at the time the court was first seized, of course, they could at any time, could they, even if there was a new party? Could
yes.
they?
Yes. Though...
Just a matter of construction of the article.
Well, yes. The party, on Mr. Sepright's interpretation, the parties are fixed at the moment, the time the court is seized.
So you don't make a good enough agreement the first time. There's no reason why you shouldn't make one later, since there's nothing about time on this analysis in the article. But suppose by this time the child is a party. Would there nevertheless be a good agreement?
There would, but at that point, if the child was a party and the guardian was instructed, then it's likely the court would consider the guardian's position on the best interest point.
So your answer to my question is it could be made at any time, this arrangement?
It could, but I'm...
As a matter of construction of the article, as I'm asking.
Yes, as a matter of construction, my lord, but it's not going to arise in practice after the question of jurisdiction is first considered by the court?
Well, I don't know.
Well, if the court has to ask itself, have I got jurisdiction? Of course, the court didn't do that in this case until very late in the day. But if it asks itself at the outset, do I have jurisdiction? Then one of the questions the judge has to consider is, do the parties agree? Or have they unequivocally accepted? If they haven't unequivocally accepted, he puts them to the election. Do you agree? If they say no, then he doesn't have jurisdiction under Article 12.3. If they say yes, then he does, and that's the end of it.
And if they came back a week later and said, OK, we've decided to agree now, that'd be all right.
Well, a week later, I dare say a week later, a judge might, a pragmatic excuse, a judge might say yes.
Or a year later.
Well, it's unlikely.
Maybe unlikely. I don't know anything. All sorts of things could happen.
Well, let us. If they say no, that's the end of the case. If they come back a year later and say we've changed our minds, then he conducts the exercise all over again, doesn't he? Because he's got a fresh application. By this stage, an express agreement. He then has to ask himself at that point, is it in the best interest of the child that I exercise jurisdiction? And he might. But he won't have jurisdiction until if there's clearly not an agreement. There's still not an agreement, but he might subsequently get jurisdiction if fresh proceedings are started when the parties agree.
And you're suggesting, are you, that in case of doubt, he should put the parties to their election? Is that something the regulation really contemplates?
Well,
I mean, it seems a strange idea, really. I mean, I can see if one was had a sort of common law freedom of choice approach to things, it might be sensible to do that, but I'm not sure that that's where the rules work under the regulation.
This regulation has never been considered by until this case, in this detail, and I dare say what happens hereafter will depend very much on what this court says. It's bound to. I imagine that judges hereafter who are considering cases where this is likely to arise, and maybe in a great number of cases, will devise a formula for asking the question to satisfy that such questions are required to be answered to satisfy themselves they have jurisdiction. Indeed, one can see that a prudent course would be for rules to be drafted which ensure that the question of agreement jurisdiction is identified and answered at the outset of the proceedings. Mm-hmm. Indeed, on the acknowledgement of service form or by some other process.
But you would presumably say that once agreement or acceptance has been manifested, it can't be withdrawn.
It can't be withdrawn. That's right. Once there is a clear agreement or sufficient demonstration of acceptance to indicate that it exists, then, provided the other tests are satisfied, then the court has jurisdiction, and on it goes to consider the case.
I mean, there is a flavour of that in Article 9.2, which is looking at continuing jurisdiction. And one thing that's clear from 9.2 is that once you've participated in proceedings without contesting jurisdiction, you can't. It's too late to start changing your mind. I mean, the thing is simply.
Well, that would certainly surely be the practical solution.
And that would be the sensible approach to 12 as well.
Family courts are busy enough, my lord, in this country. Not going to want to be overburdened with the prospect of ongoing issues as to jurisdiction. They want to use my lady's phrase for another case, a swift, unsentimental approach to decision on jurisdiction. Yes. And then get on with the
It's absolutely fine within the member states, because then you've got Article 15 to fall back on, as we can see, and from the experience you've had, it seems to work reasonably well. One can understand all of that. It's really the third state problem that is the difficulty.
Well, I don't propose to say anything further than Mr. Sebright's observations about the possibility of a transfer with third states. Although, of course, as we've seen earlier, under the Hague Convention, there is a similar process under Articles 8 and 9 of the Hague Convention for the orderly transfer. So in due course, it would seem, if it's right, the Hague Convention is in due course ratified by more and more countries, then this process may come in time to be the norm, although there will still be many countries, and perhaps, I may say so, countries in the Islamic world would be the obvious example. There will be many countries where there are no such agreements in place. So I was just going to make one or two observations about other matters which have arisen very briefly. First of all, Milady has been concerned about the proceedings before District Judge Brass, and by which I mean in particular the reopening of the findings.
Yes, but I have been somewhat reassured by what Miss Russell said, unless you wish to disagree with what Miss Russell said.
I just wanted to inform the court, I accept that there is power under Order 37 of the County Court rules which still apply for these purposes for the court to have a rehearing. Have you marked it up? Yeah, you did. In any proceedings tried without a jury, the judge shall have power on application to order a rehearing where no error at the hearing is alleged. And there's some case law as to when it's appropriate to have a rehearing and when it's appropriate to have when it's necessary to go to an appeal. The relationship may recall a particular decision of Lord Justice Ward some years ago on that point. But in this case, they're clearly, in circumstances where there is fresh evidence that has emerged, then the court has a discretion to conduct a rehearing. The complaint in this case was the procedure that the mother was not given proper notice of the judge's intention to review the findings, and that and furthermore her cross-examination of the father on those allegations was unfairly curtailed. And that was the subject of an appeal, first of all, to Mrs. Justice Hogg in 2004, and then some years later, an attempt to appeal the decision of Mrs. Justice Hogg, who refused the appeal in 2004. An attempt was made to appeal Mrs. Justice Hogg's decision in 2007 to the Court of Appeal. On that occasion, permission to appeal was refused. Of course, by that stage, the order against which an appeal was being attempted was several years old, and as I understand it, I didn't appear on that occasion. As I understand it, the Court of Appeal took the view that it could not be justified in the circumstances of that case reopening an issue. There was no reason to reopen an issue at that stage after such a length of time. But the concern, as I say, was not that the court had the power, but the way in which it was executed in that case.
Thank you.
Milady has, and the court has raised the question of undertakings to return. This featured substantially in the submissions made by Milady Jr. and Mr. Devereux before Judge Barnett on the basis of the case that was then being advanced. And it might be interesting just to look briefly at his judgment, which is in Appendix Part 1, tab 4.
Yes.
It's as a report from the family law courts. And Mr. Devereux makes at paragraph 35, Mr. Devereux, alternatively, Mr. Devereux says that the mother invokes the inherent jurisdiction of the higher court alone, and or two, relies on the undertaking recorded upon the order granted to leave to remove whereby the father undertook to return the child Q when ordered to do so by the court. Mr. Devereux submitted that the undertaking is of critical importance and provided, or potentially provided, the legal foundation for the order Mr. Justice Headley made on the 17th of June 2008, requiring the father to return Q to the jurisdiction. In this context, Mr. Devereux invited me not to follow the approach and reasoning of Mr. Justice Thorpe as he then was in Ries. I will consider the relevant section of Ries below, that's fact 36. In paragraph 36, he quotes Mr. Justice Thorpe saying as follows in Ries: the first undertaking, the conventional undertaking to return the child to this jurisdiction, if ordered so to do, has for many years automatically been extracted from any successful applicant for leave to take a child permanently from the jurisdiction. It had undoubtedly a useful function in the days when the movement of children across international boundaries was not regulated by international convention and statute as it is today, but in the age that succeeds the Hague Convention, the Child Abduction and Custody Act of 1985 and the Family Law Act 1986, I cannot see that the conventional undertaking has a surviving use or function. Mr. Deverick submitted that such reasoning was only persuasive. Strictly speaking, that may be so, but the analysis is that of a judge whose expertise and experience in international cases is only too well known. Mr. Deverick also says that the present case is clearly distinguishable because the relocation was, of course, to Pakistan, a non-convention country. That is so, notwithstanding the Pakistan Protocol, I acknowledge the difficulties in securing the return of a child from Pakistan to this country. However, those points do not, in my judgment, destroy the fundamental basis of the reasoning behind the passage quoted above, which I am happy to accept. However, let it be assumed that I am wrong and that the undertaking in this case is of importance and can and should it be enforced, does it of itself confer jurisdiction? In my judgment, it does not. And then he goes on in the judgment. Well, my Lord, this case, I venture to suggest, has proved the ongoing value of undertakings, because if your Lordship and the Lords and my Lady accept our submissions, the undertaking given by the father to, on the occasion of his being granted permission to remove the child, has been ultimately of very great importance in establishing the ongoing jurisdiction. The decision in the decision of Mr. Justice Thorpe, as he then was, is at tab 13 in the Authorities Bundle, Volume 1, if the Court wishes to consider it at some point. I wasn't proposing to turn to it now because the relevant passage from the judge's judgment in Ries is quoted by Judge Barnett.
Yes, well, at least we know where it is. Thank you very much. Yeah.
Of course, he doesn't seem to have been addressing his mind to what the situation is, where one of the countries involved is not a party to any of those international agreements. And the other thing is that he's not addressing his mind to what the continuing force of the undertaking is. He's simply saying, why bother to extract it if there are other ways of regulating the situation?
Yes.
The question with which we're concerned really is, what is the continuing force of such an undertaking in a case which is not governed by any binding international law obligations?
Yes.
In any event, the threat of imprisonment might be rather more effective than proceedings in a foreign country under the Hague Convention.
Yes.
Well, it is how we used to enforce, equity used to enforce everything, by making injunctions or extracting undertakings and enforcing them against the person. I can't think how Penn and Baltimore actually got itself anywhere without that. So the fact that people are in another country doesn't necessarily deter the court from doing that.
That's how we've always justified the anti-suit injunction, but it's not something which the European Court cares for.
Well, for our part, we submit that in this case demonstrates the importance of the ongoing importance of undertakings in cases, in particular, where children are being removed to countries who are neither parties to the European regulations or to the Hague Convention.
Or where, and particularly where the parent is or may be coming back here.
Yes, they are of particular importance in those circumstances for enforcement reasons.
Well, then, I mean, the undertaking is truly enforceable in those cases.
It's, yes. Was there any other matter upon which the court required my further submissions?
I don't think there is. Thank you very much indeed. Well, the court is extremely grateful to counsel on all sides for their help in these interesting discussions during these past 2 days, and also to the assistance of those behind them. We will take time to consider our judgment.